Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah.
Hey guys, welcome back to another court update video. Now we're here to get into Meg and Pete versus Milagro Elizabeth Cooper. Now, recently they did come to an agreement with the joint proposed jury instructions. So that is what we will be reading today. And before we actually get started, let's make sure that y'all see my copyright disclaimer at the very bottom on the section 107, just simply saying that, hey, this is fair use. I am not a paralegal. I am not an attorney, and I am not a judge. I am simply saying that, hey, I know how to read. And without further ado, we're going to get into the actual joint proposed jury instructions. All right. Now, for those of y'all who do not know or already aware, Meg and Pete's legal team, when it came down to the deadline, they went ahead and put out their jury instructions and also their verdict form. I will be creating a separate video for the verdict form, but just to give y'all a little context, they went ahead to meet the deadline. They went ahead and put out the jury instructions in the verdict form. Milagro's legal team, they did request an extension for their joint proposed jury instructions in verdict form, and that was ultimately granted. And the previous proposed jury instructions in verdict form on Meg and Pete's legal team side was stricken because you're supposed to do it together. However, they wanted to do their part by getting it in on the actual deadline. So we're here again today to go over this particular court document. And like I said, I will create a separate video for the verdict form. So let's go ahead and get started. Pursuant to the court's case management and scheduling order, you can refer back to docket 62, plaintiff Megan Pete, Miss Pete, and defendant Milagro Elizabeth Cooper, Miss Cooper, respectfully submit their proposed jury instructions. The parties respectfully reserve the right to amend their jury instructions prior to the time it is given to the jury, depending on the evidence received at trial, the court rulings, or any other factors that preclude a definitive submission at this time. All right, so let's go ahead and get started. So instruction number 1, general preliminary instruction. Members of the jury, now that you've been sworn, I need to explain some basic principles about a civil trial and your duty as jurors. These are preliminary instructions. I'll give you more detailed instructions at the end of the trial. The jury's duty. All right, so when it comes down to the jury duty, it is your duty to listen to the evidence, decide what happened, and apply the law to the facts. It's my job to provide you with the law. You must apply, and you must follow the law even if you disagree with it. What is evidence? You must decide the case on only the evidence presented in the courtroom. Evidence comes in many forms. It can be testimony about what someone saw, heard, or smelled. It can be an exhibit or a photograph. It can be someone's opinion. Some evidence may prove a fact indirectly. Let's say a witness saw wet grass outside and people walking into the courtroom or the courthouse carrying wet umbrellas. This may be indirect evidence that it rained, even though the witness didn't personally see it rain. Indirect evidence like this is also called circumstantial evidence, simply a chain of circumstances that likely proves a fact. As far as the law is concerned, it makes no difference whether evidence is direct or indirect. You may choose to believe or disbelieve either kind. Your job is to give each piece of evidence whatever weight you think it deserves. What is not evidence? During the trial, you'll hear certain things that are not evidence and you must not consider them. First, the lawyer's statements and arguments are evidence. In their opening statements and closing arguments, the lawyers will discuss the case. Their remarks may help you follow each side's arguments and presentation of evidence, but the remarks themselves aren't evidence and shouldn't play a role in your deliberations. Second, the lawyer's questions and objections aren't evidence. Only the witness answers are evidence. Don't decide that something is true because a lawyer's question suggests that it is. For example, a lawyer may ask a witness, "You saw Mr. Jones hit his sister, didn't you?" That question is not evidence of what the witness saw or what Mr. Jones did, unless the witness agrees with it. There are rules of evidence that control what the court can receive into evidence. When a lawyer asks a witness a question or presents an exhibit, the opposing lawyer may object if he or she thinks the rules of evidence don't permit it. If I overrule the objection, then the witness may answer the question or the court may receive the exhibit. If I sustain the objection, then the witness cannot answer the question and the court cannot receive the exhibit. When I sustain an objection to a question, you must ignore the question and not guess what the answer might have been. Sometimes I may disallow evidence. This is also called striking evidence in order you to disregard or ignore it. That means that you must not consider the evidence when you are deciding the case. I may allow some evidence for only a limited purpose. When I instruct you that, I have admitted an item of evidence for a limited purpose. You must consider it for only that purpose and no other. Credibility of witness. To reach a verdict, you may have to decide which testimony to believe and which testimony not to believe. You may believe everything a witness says, part of it, or none of it. When considering a witness testimony, you may take into account the witness's opportunity and ability to see, hear, or know the things the witness is testifying about, the witness memory, the witness manner while testifying, any interest the witness has in the outcome of the case, any bias or prejudice the witness may have, any other evidence that contradicts the witness's testimony, the reasonableness of the witness testimony in light of the evidence, and any other factors affecting believability. At the end of the trial, I'll give you additional guidelines for determining a witness's credibility. Description of the case. This is a civil case. To help you follow the evidence, I'll summarize the parties' positions. The plaintiff, Ms. Megan Peet, claims the defendant, Ms. Milagro Cooper, defamed her by falsely accusing her of committing a crime of perjury, being an alcoholic, and being mentally incapacitated, and either needing or already having a guardian. Second, Ms. Peet alleges that Ms. Cooper promoted a deep fake pornographic video of Ms. Peet, despite reasonably knowing that the visual depiction was artificially created. Third, Ms. Peet claims that Ms. Cooper intentionally engaged in this conduct and that the conduct caused her severe emotional distress. Fourth, Ms. Peet claims that Ms. Cooper engaged in cyber stalking by engaging in this behavior through electronic means. In this civil case, Megan Peet, professionally known as Megan the Stallion, alleges that Milagro Cooper defamed her by falsely accusing her of perjury, alcoholism, and mental incapacity, and that Cooper promoted a deep fake pornographic video despite reason to know it was artificial, and that this online conduct intentionally caused severe emotional distress and constituted cyber stalking. Cooper denies all allegations in any coordination with Mr. Peterson, describing herself as a social media commentator sharing opinions with the hip-hop community. She acknowledges questioning Pete's credibility, but maintains that any public criticism stems from Pete's own actions and statements, not from Cooper's conduct. Burden of proof. There are certain claims and elements that Ms. Peet has the burden of proving her case by what the law calls as preponderance of the evidence. That means Ms. Peet must prove that in light of all the evidence, what she claims is more likely true than not. If you could put the evidence favoring Miss Pete and the evidence favoring Miss Cooper on opposite sides of balancing scales, Miss Pete needs to make the scales tip to her side. If Miss Pete fails to meet this burden, you must find in favor of Miss Cooper. To decide whether any fact has been proved by the preponderance of the evidence, you may, unless I instruct you otherwise, consider the testimony of all witnesses, regardless of who called them, and all exhibits that the court allowed, regardless of who produced them. After considering all the evidence, if you decide a claim or fact is more likely true than not, then the claim or fact has been proved by the preponderance of the evidence. There are other claims and elements that Ms. Pete will have the burden of proving her case by what the law calls clear and convincing evidence. Clear and convincing evidence is a higher standard of proof than proof by the preponderance of the evidence. It means that evidence must persuade you that the claim or defense is highly probable or reasonably certain. The court will tell you when to apply the standard. On certain issues called affirmative defenses, Ms. Cooper has the burden of proving the elements of a defense by a preponderance of the evidence. I'll instruct you on the facts Ms. Cooper must prove for any affirmative defense. After considering all the evidence, if you decide that Ms. Cooper has successfully proven that the required facts are more likely true than not, the affirmative defense is proved. Conduct of the jury. While serving on the jury, you may not talk with anyone about anything related to the case. You may tell people that you're a juror and give them information about when you must be in court, but you must not discuss anything about the case itself with anyone. You shouldn't even talk about the case with each other until you begin your deliberations. You want to make sure you've heard everything, all the evidence, the lawyers, closing arguments, and my instructions on the law before you begin deliberating. You should keep an open mind you should keep an open mind until the end of the trial. Premature decisions may lead to a premature decision. In this age of technology, I want to emphasize that in addition to not talking face to face with anyone about the case, you must not communicate with anyone about the case by any other means. This includes emails, text messages, phone calls, and the internet, including social networking, websites, and apps such as Facebook, Instagram, Snapchat, YouTube, and Twitter. You may not use any similar technology of social media, even if I have not specifically mentioned it here. You must not provide any information about the case to anyone by means whatsoever, and that includes posting information about the case or what you are doing in the case on any device or internet site, including blogs, chat rooms, social websites, or any other means. You also shouldn't Google or search online or offline for any information about the case, the parties, or the law. Don't read or listen to the news about this case, visit any places related to this case, or research any fact, issue, or law related to this case. The law forbids the jurors to talk with anyone else about the case and forbids anyone else to talk to the jurors about it. It's very important that you understand why these rules exist and why they are so important. You must base your decision only on the testimony and other evidence presented in the courtroom. It is not fair to the parties if you base your decision in any way or information you acquire outside the courtroom. For example, the law often uses words and phrases in special ways, so it's important that any definitions you hear come only from me and not from any other source. Only you jurors can decide a verdict in this case. The law sees only you as fair, and only you have promised to be fair. No one else is so qualified. Taking notes. If you wish, you may take notes to help you remember what the witnesses said. If you do take notes, please don't share them with anyone until you go to the jury room to decide the case. Don't let note taking distract you from carefully listening to and observing the witnesses. When you leave the courtroom, you should leave your notes hidden from view in the jury room. Whether or not you take notes, you should rely on your own memory of the testimony. Your notes are there only to help your memory. They are not entitled to greater weight than your memory or impression about the testimony. Course of the trial. Let's talk through the trial. First, Each side may make an opening statement, but they don't have to. Remember, an opening statement isn't evidence, and it's not supposed to be argumentative. It's just an outline of what the party intends to prove. Next, Ms. Peak will present her witnesses, and ask them questions. After Ms. Peak questions the witnesses, Ms. Cooper may ask the witness questions. This is called cross-examining the witness. Then Ms. Cooper will present her witnesses, and Ms. Peak may cross-examine them. You should base your decision on all the evidence, regardless of which party presented it. After all, the evidence is in, the party's lawyers will present their closing arguments to summarize and interpret the evidence for you. And then I'll give you instructions on the law. You'll then go into the jury room and deliberate. So instruction number 2, which is burden of proof, clear and convincing evidence. Sometimes a party has the burden of proving a claim or defense by clear and convincing evidence. This is a higher standard of proof than proof by a preponderance of the evidence. It means the evidence must persuade you that the claim or defense is highly probable or reasonably certain. The court will tell you when to apply this standard. And this is the sources from the 11th Circuit Pattern Jury Instructions, which y'all see right there. Okay, let's go down to jury instruction number 3, which is jury instructions. During this trial, you may submit questions to a witness after the lawyers have finished their own questioning. Here is how the procedure works. After each witness has testified and the lawyers have asked all of their questions, I'll ask if any of you have questions. If you have a question, write it down and give it to the court staff. You may submit a question for a witness only to clarify the answer or to help you understand the evidence. Our experience with juror questions indicates that jurors rarely have more than a few questions for any one witness, and there may be no questions at all for some witnesses. If you submit a question, the court staff will give it to me, and I'll share your questions with the lawyers in the case. If the rules of evidence allow your question, one of the lawyers or I will read your question to the witness. I may modify the form of phrasing of a question so that it'll say that it's allowed under the evidence rules. Sometimes I may not allow the questions to be read to the witness, either because the law does not allow it or because another witness is in a better position to answer the question. If I can't allow the witness to answer the question, you must not draw any conclusions from that fact or speculate on what the answer might have been. Here are several important things to keep in mind about your questions for the witnesses. First, you must submit all questions in writing. Please don't ask any questions aloud. Second, the courts can recall witnesses to the stand for additional juror questions. If you have a question for a particular witness, you must submit it when I ask. Finally, because you should remain neutral and open-minded throughout the trial, you should phrase your questions in a way that doesn't express an opinion about the case or a witness. You must keep an open mind until you've heard all the evidence, the closing arguments, and my final instructions of the law. Instruction number 4, which is stipulations. Sometimes the parties have agreed that certain facts are true. This agreement is called a stipulation. You must treat these facts as proved for the case. Instruction number 5, which is use of depositions. A deposition is a witness sworn testimony that is taken before the trial. During a deposition, the witness is under oath and swears to tell the truth, and the lawyers for each party may ask questions. A court reporter is present and records the questions and answers. The deposition of name of witness taken on date is about to be, has been presented to you by a video by reading the transcript. Deposition testimony is entitled to the same consideration as live testimony, and you must judge it in the same way as if the witness was testifying in court. Do not place any significance on the behavior or tone or voice of any person reading the questions or answers. Instruction number 6, which is the use of recorded conversations and transcripts. Now, you're going to hear a recorded conversations. This is proper evidence for you to consider. Please listen to it very carefully. I'm going to allow you to have a transcript of the reading of the recording prepared by name of prepare to help you identify speakers and guide you through the recording. But remember that it is the recording that is evidence, not the transcript. If you believe at any point that the transcript says something different from what you hear on the recording, disregard that portion of the transcript and rely instead of what you hear or on what you hear. Instruction number 7, which is judicial notice. The rules of evidence allow me to accept facts that no one can reasonably dispute. The law calls this judicial notice. I've accepted, state the fact that the court has judicially noticed as proved, even though no one introduced evidence to prove it. You must accept it as true for this case. Instruction number 8, which is use of interrogatories. You've heard answers that name of party gave in response to written questions the other side submitted. The questions are called interrogatories. Before the trial, name of party gave the answers in writing while under oath. You must consider name of party's answers too as though name of party gave the answers on the witness stand. Instructions number 9, which is in-trial instructions of news coverage. Reports about this trial may appear in the media. The reporters may not have heard all the testimonies as you have, may be getting information from people who are not under oath and subject to cross-examination, may emphasize an unimportant point, or may simply be wrong. You must not read, listen to, or watch anything about this trial. It would violate your oath as a juror to decide this case on anything other than the evidence presented at trial and on your own common sense. You must decide this case exclusively on the evidence you receive here in court. Instruction number 10 was this introduction, final charge to jury. Court instructions to the jury. Members of the jury, it's my duty to instruct you on the rules of law that you must use in deciding this case. When I have finished, you will go to the jury room and begin your discussions, sometimes called deliberations. Instruction number 7, which is duty to follow instructions. No corporate party allowed. Your decision must be based only on the evidence presented here. You must not be influenced by any way by either sympathy or by prejudice against anyone. You must follow the law as I explain it, even if you do not agree with the law, and you must follow all of my instructions as a whole. You must not single out or disregard any of the instructions of the law. All right, so we are on instruction number 12, which is consideration of direct and circumstantial evidence, argument of counsel, comments by the court. You must consider only the evidence that I have admitted in the case. Evidence includes the testimony of witnesses and the exhibits admitted, but anything the lawyers say is not evidence and isn't binding on you. You shouldn't assume from anything I've said that I have any opinion about any factual issue in the case, except for my instructions to you on the law. You should disregard anything I may have said during the trial in arriving at your own decision about the facts. Your own recollection and interpretation of the evidence is what matters. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You shouldn't be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain of facts and circumstances that tend to prove or disprove a fact. There is no legal difference in the weight you may give to either direct or circumstantial evidence. Instruction number 13, which is credibility of witness. When I say you must consider all the evidence, I don't mean that you must accept all the evidence as true or accurate. You should decide whether you believe what each witness had to say or how important that testimony was. In making that decision, you may believe or disbelieve any witness in whole or in part. The number of witnesses testifying concerning a particular point doesn't necessarily matter. To decide whether you believe any witness, I suggest that you ask yourself a few questions. And as y'all can see, there's 7 bullet points here, so we're going to get through it. Number 1, did the witness impress you as one who was telling the truth? Number 2, did the witness have any particular reason not to tell the truth? Number 3, did the witness have a personal interest in the outcome of the case? Number 4, did the witness seem to have good memory? Number 5, did the witness have the opportunity and ability to accurately observe the things he or she testified about? Number 6, did the witness appear to understand the questions clearly and answer them directly? And number 7, did the witness testimony differ from other testimony or other evidence? All right, so we're going to get into instruction number 14, which is impeachment of witness because of inconsistent statements or felony conviction. You should also ask yourself whether there was evidence that a witness testified falsely about an important fact. and ask whether there was evidence that at some other time a witness said or did something, or didn't say or do something that was different from the testimony the witness gave during this trial. To decide whether you believe a witness, you may consider the fact that the witness has been convicted of a felony or a crime involving dishonesty or a false statement. But keep in mind that a simple mistake doesn't mean a witness wasn't telling the truth as he or she remembers it. People naturally tend to forget some things or remember them inaccurately. So if a witness misstated something, you must decide whether it was because of an innocent lapse in memory or an intentional deception. The significance of your decision may depend on whether the misstatement is about an important fact or about an unimportant detail. Number 15, this is instruction number 15, which is expert witnesses. When scientific, technical, or other specialized knowledge might be helpful, a person who has special training or experience in the field is allowed to state an opinion about the matter, but that doesn't mean you accept the witness' opinion. As with any other witness testimony, you must decide for yourself whether to rely upon the opinion. All right, so now we're on instruction number 16, which is responsibility for proof, plaintiff's claims, cross claims, counterclaims, preponderance of the evidence. In this case, it is the responsibility of Ms. Pete to prove every essential part of her claims by a preponderance of the evidence. This is sometimes called burden of proof or the burden of persuasion. So she has to persuade, as y'all can see there. In certain instances, it is the responsibility of Ms. Pete to prove every essential part of her claims by a preponderance of the evidence. This is sometimes called the burden of proof or the burden of persuasion. A preponderance of the evidence simply means an amount of evidence that is enough to persuade you that Ms. Pete's claim is more likely true than not true. If the proof fails to establish any essential part of a claim or contention by a preponderance of the evidence, you should find against Ms. Pete. In other instances, which I will inform you of, it will be Ms. Pete's responsibility to prove certain elements or claims by clear and convincing evidence. Clear and convincing evidence is a higher standard of proof than proof by preponderance of the evidence. It means the evidence must persuade you that the claim or defense is highly probable or reasonably certain. The court would tell you when to apply this standard. Because more than one claim is involved, you should consider each claim separately. In deciding whether any fact has been proved by the burden of proof, you may consider the testimony of all of the witnesses, regardless of who may have called them, and all of the exhibits received in evidence, regardless of who may have produced them. If the proof fails to establish any essential part of Ms. Pete's claims by the applicable burden of proof, P, you should find for Ms. Cooper to that claim. Instruction number 17. All right. This is responsibility for proof, affirmative defense, preponderance of the evidence. In this case, Ms. Cooper asserts the following affirmative defenses: substantial truth doctrine, and the single publication rule limits or bars the claims. Even if Ms. Pete proved her claims by preponderance of the evidence or clear and convincing evidence, Ms. Cooper can prevail in the case if she proves an affirmative defense by preponderance of the evidence. When more than one affirmative defense is involved, you should consider each one separately. I caution you that Ms. Cooper does not have to disprove Ms. Pete's claims. But if Ms. Cooper raises an affirmative defense, the only way she can prevail on that specific defense is if she proves that defense by the preponderance of the evidence. Instruction number 18, preponderance of the evidence. Preponderance of the evidence means the more persuasive and convincing force and effect of the entire evidence in this case, Instruction number 19, which is clear and convincing evidence. Clear and convincing evidence differs from the greater weight of the evidence, and that is more compelling and persuasive. Clear and convincing evidence is evidence that is precise, explicit, lacking in confusion, and of such weight that it produces a firm belief or a conviction without hesitation about the matter in issue. Instruction number 20, which is defamation per se. The plaintiff, Ms. Pete, claims that the defendant, Ms. Cooper, defamed her by publishing false statements about her on social media, which caused Mrs. Pete harm. Mrs. Pete claims Ms. Cooper defamed her by making the following statements. 1, that Ms. Pete committed perjury, a felony, by lying under oath in a criminal trial. Number 2, that Ms. Pete is mentally incapacitated, slow, legally for YouTube purposes, we won't say that. We'll just say the R word, or either as or requires a guardian in that Miss P is an alcoholic or comes from a family of addicts. The issue must decide for Miss P's claim of defamation against Miss Cooper are: first, whether Miss Cooper published a statement about Miss P; second, whether the statement was in some significant respect false; and whether Ms. Cooper either knew the statement was false or had serious doubts as to its truth. Third, whether the statement was defamatory, and if so, fourth, whether Ms. Cooper's defamatory statement was a legal cause of loss, injury, or damage to Ms. P. The first issue you must decide is whether Ms. Cooper published the statements. A statement is published when it is communicated to someone other than Ms. P or Ms. Cooper. In order to be communicated, a statement must be read, seen, or heard by a person other than Ms. P or Ms. Cooper that the person must understand the statement's significance. A separate publication occurs each time Ms. Cooper communicates the statement to someone other than Ms. P, except that a single communication read, seen, or heard at the same time by two or more people is only a single publication. The next issue for you to decide is whether Ms. Cooper's statement concerning Ms. P was in some significant respect a false statement of fact, and if so, whether at the time the statement was made, Ms. Cooper either knew the statement was false or had serious doubts as to its truth. A statement is in some significant respect false if its substance or gist conveys a materially different meaning than the truth would have conveyed. In making this determination, you should disregard any minor inaccuracies that do not affect the substance of the statement. A statement that is literally true is in some significant respect a false statement of fact if it is conveyed in such a way as to create a false impression. In order to be regarded as defamatory, a statement must be one of fact, not opinion. However, a statement involved or phrased as opinion is considered to be in a statement of fact, and it is capable of being proved false, or if it implies a knowledge or unstated facts that would support the opinion. You must decide whether clear or convincing evidence shows that at the time of the statement was made, Ms. Cooper either knew the statement was false or had serious doubts as to its truth. Ms. Pete's defamation claim is what is known under Florida law as defamation per se. Florida law holds that certain statements are so harmful in nature that they are presumed defamatory. Getting tongue tied, y'all. Defamatory as a matter of law. In a claim for defamation per se, the harmful nature of the statement is apparent from the words in the statement itself. Therefore, the plaintiff in a defamation per se action does not need to allege damages because the harm is readily apparent. The court has determined that the statements Ms. P complains of are defamatory per se. Therefore, you may assume as part of your deliberation that these statements are defamatory. Next, you must decide whether the statement was a legal cause of loss, injury, or damages to Ms. P. A statement is a legal cause of loss, injury, or damage if it directly and in natural and continuous sequence produces or contributes substantially or sustainably. Oh, I'm getting tongue tied, y'all. Y'all give me 1 second. Substantially, however you say that, whatever, we're going to continue to produce in such loss, injury, or damage so that it can reasonably be said that, but for the statement, the loss, injury, or damage would not have occurred. In order to be regarded as a legal cause of loss, injury, or damage, a statement need not be the only cause. A statement may be a legal cause of loss, injury, or damage, even though it operates in combination with the fact of another or some other cause if the statement contributes substantially to producing such loss, injury, or damage. Ms. Peake must prove the second element, falsity, by clear and convincing evidence. Clear and convincing evidence is a higher standard of proof than proof by a greater weight of the evidence or preponderance of the evidence. It means the evidence must persuade you that the claim or defense is highly probably or reasonably certain. If Ms. P has not proven falsity by clear and convincing evidence, then your verdict form should be for Ms. Cooper. If the greater weight of the evidence or preponderance of the evidence does not support the other elements of Ms. P's defamation claim, then your verdict should be for Ms. Cooper. However, if Ms. P has proved her claim, then you will consider the defense raised by Ms. Cooper. Defenses. You must now consider Ms. Cooper's defenses. 1. Truth. Ms. Cooper contends that the allegedly defamatory statements were true. Truth is an absolute defense for defamation. As to this defense, the issue for your determination is whether the statements made by defendant were substantially true and were made by defendant with good motives. A statement is substantially true if the substance or gist conveys essentially the same meaning that the truth would have conveyed. In making this determination, you should consider the context in which the statement is made and disregard any minor inaccuracies that do not affect the substance of the statement. If the preponderance of the evidence support the defense, your verdict should be for Ms. Cooper. If the preponderance of the evidence does not support the defense, your verdict should be for Ms. P. Okay, so we're on instruction number 20, defamation. We're on page 32 of 46, okay? So I'm reading kind of fast, y'all. We're reading kind of fast. Defamation. The plaintiff, Ms. Pete, professionally known as Megan Thee Stallion, claims that the defendant, Ms. Cooper, defamed her by publishing false statements about her on social media, which caused Ms. Pete harm. Ms. Pete claims Ms. Cooper defamed her by making the following statements. Number one, that Ms. Pete committed perjury, a felony by lying under oath in a criminal trial. Number two, that Ms. Pete is mentally incapacitated, slow, legally or word, or either has or requires a guardian. And three, that Ms. P is an alcoholic or comes from a family of addicts. The issues you must decide for Ms. Pete's claim of defamation against Ms. Cooper are, first, whether Ms. Cooper published a statement about Ms. Pete. Second, whether the statement was in some significant respect false. Third, whether Ms. Cooper made the statement with actual malice. Fourth, whether Ms. Pete suffered actual damage as a result of the statement. And fifth, whether Ms. Cooper's defamatory statement was a legal cause of loss, injury, or damage to Ms. Pete. The first issue you must decide is whether Ms. Cooper published the statements. A statement is published when it is communicated to someone other than Ms. Pete or Ms. Cooper. In order to be communicated, a statement must be read, seen, or heard by a person other than Ms. Pete or Ms. Cooper, and that person must understand the statement's significance. A separate publication occurs each time Ms. Cooper communicates the statement to someone other than Ms. Pete, except that a single communication read, seen, or heard at the same time by two or more people is only a single publication. The next issue for you to decide is whether Ms. Cooper's statement concerning Ms. Pete was in some significant respect a false statement of fact, and if so, whether at the time the statement was made, Ms. Cooper made the statement with actual malice. A statement is in some significant respect false if its substance or gist conveys a materially different meaning than the truth would have conveyed. In making this determination, you should disregard any minor inaccuracies that do not affect the substance of that statement. Next, you must decide whether the statement was a legal cause of loss, injury, or damages to Ms. Pete. A statement is a legal cause of loss, injury, or damage if it directly and in natural and continuous sequence produces or contributes substantially to producing such loss, injury, or damage so that it can reasonably be said that but for the statement, the loss, injury, or damage would not have occurred. Actual malice is defined as knowledge that a statement is false or reckless disregard for whether the statement is false. Actual malice requires more than a departure from reasonable journalistic standards. A failure to investigate, standing on its own, does not indicate the presence of actual malice. To show actual malice, a plaintiff must produce evidence showing that the defendant purposefully avoided further investigation with the intent to avoid the truth. Ms. Pete must prove actual malice by clear and convincing evidence. Clear and convincing evidence is a higher standard of proof than proof by the preponderance of the evidence. It means the evidence must persuade you that the claim or defense is highly probably or reasonably certain. If Ms. Pete has not proven actual malice by clear, convincing evidence, then your verdict should be for Ms. Cooper. Next, you must decide whether the statement was a legal cause of loss, injury, or damages to Ms. Pete. A statement is a legal cause of loss, injury, or damage if it directly in a natural and continuous sequence produces or contributes substantially to producing such loss, injury, or damage so that it can reasonably be said that but for the statement, the loss, injury, or damage would not have occurred. If the appropriate burden of proof does not support the elements of Ms. Pete's defamation claim, then your verdict must be for Ms. Cooper. Actual malice must be proved by clear and convincing evidence. The remaining elements must be proven by a preponderance of the evidence. However, if Ms. Pete has proved her claim, then you will consider the defense raised by Ms. Cooper. Defenses. You must now consider Ms. Cooper's defenses. Substantial truth doctrine. Ms. Cooper contends that the allegedly defamatory statements were true. Truth is an absolute defense of defamation. To succeed on this defense, Ms. Cooper must prove by the preponderance of the evidence that the alleged defamatory statement was substantially true, or the gist conveys essentially the same meaning that the truth would have conveyed. If the preponderance of the evidence support this evidence, your verdict should be for Ms. Cooper. If the preponderance of the evidence does not support this evidence, your verdict should be for Mrs. P. Instruction number 21, which is intentional infliction of emotional distress. Ms. P claims that Cooper acted extremely and outrageously by coordinating with Mr. Daystar Peterson and others to distribute false statements about Ms. P and to promote and distribute an altered sexual depiction of Ms. P, which caused her severe emotional distress. Defendant denies plaintiff's claim. The issues for you to decide on Ms. P's claim are intentional infliction of emotional distress, or first, whether Ms. Cooper engaged in extreme and outrageous conduct. Second, whether Ms. Cooper acted with the intent to cause severe emotional distress or with reckless disregard of the high probability of causing severe emotional distress. Third, whether that extreme or outrageous conduct was a legal cause of severe emotional distress to Ms. P. Extreme and outrageous conduct is behavior which, under the circumstances, goes beyond all possible bounds of decency and is regarded as shocking, atrocious, and utterly intolerable in a civilized community. Emotional distress is severe when it is such intensity or duration that no ordinary person should be expected to endure it. Extreme and outrageous conduct is a legal cause of severe emotional distress if it directly and in natural and continuous sequence produces or contributes substantially to producing such severe emotional distress, so that it can reasonably be said that, but for the extreme and outrageous conduct, the severe emotional distress would not have occurred. In order to disregard as a legal cause of severe emotional distress, extreme and outrageous conduct need not be the only cause. Extreme and outrageous conduct may be a legal cause of severe emotional distress, even though it operates in combination with with the act of another or some other cause. If the extreme or outrageous conduct contributes substantially to producing such severe emotional distress, if the preponderance of the evidence does not support Mrs. P's claim, your verdict should be for Ms. Cooper. However, if the greater weight of the evidence support Mrs. P's claim, then your verdict should be for Mrs. P and against Ms. Cooper. Then you shall consider the defense raised by Ms. Cooper. Okay, so we are on instruction number 21, intentional infliction of emotional distress. Ms. P brings a claim that Ms. Cooper for intentional infliction of emotional distress. The issues for you to decide for Mrs. P claim of intentional infliction of emotional distress are: first, whether Ms. Cooper engaged in deliberate or reckless infliction of emotional suffering, extreme and outrageous conduct. Second, whether Ms. Cooper's conduct was outrageous. Third, whether Ms. Cooper's conduct caused Mrs. P emotional distress. Fourth, whether the distress was severe. Extreme and outrageous conduct is behavior which, under the circumstances, go beyond all possible bounds of decency and is regarded as shocking, atrocious, and utterly intolerable in a civilized community. Emotional distress is severe when it is of such intensity or duration that no ordinary person should be expected to endure it. Extreme and outrageous conduct is a legal cause of severe emotional distress if it directly and natural in continuous sequence produces or contributes substantially to producing such severe emotional distress, so that it can reasonably be said that, but for the extreme and outrageous conduct, the severe emotional distress would not have occurred. If the preponderance of the evidence does not support Mrs. P's claim, your verdict must be for Mrs. Cooper. However, if the preponderance of the evidence support Mrs. P's claim, then your verdict must be for Mrs. P and against Mrs. Cooper. Then you must consider the defense raised by Ms. Cooper. And it says source, Florida Standard Jury Instruction. So y'all can see that there on the screen. All right, so defenses. You must now consider Mrs. Cooper's defenses. One, single publication rule. Ms. Cooper contends that this action is barred by the single publication rule. The issues for you to decide on Ms. Cooper's defense of the single publication rule are as follows. First, whether the plaintiff claim for intentional infliction of emotional distress is based solely on alleged defamatory statements and second, whether those alleged defamatory statements are the same statements relied on in the plaintiff's defamation claim. If you find that the preponderance of the evidence support both elements, your verdict should be for Mrs. Cooper. However, if the preponderance of the evidence does not support the defense, your verdict should be for Ms. P and against Ms. Cooper. Okay, so instruction number 22, promotion of an altered sexual depiction. Ms. P claims that defendant willfully and maliciously promoted a deepfake pornographic video of Ms. P on social media without Mrs. P consent. Ms. P alleges that Ms. Cooper knew and reasonably should have known that the visual depiction of plaintiff was in fact an altered sexual depiction, more commonly known as deepfake. The issues for you to decide on Mrs. P claim of promotion of an altered sexual depiction are: first, whether Ms. Cooper willfully and maliciously promoted an altered sexual depiction of an identifiable person, namely Ms. P. Second, Ms. Cooper promoted an altered sexual depiction without the consent of Ms. P. Third, at the time of promotion, Ms. Cooper knew or reasonably should have known that the visual depiction was an altered sexual depiction. I will now define some of the terms. I will now define some of the terms you must consider in deciding this claim. Altered sexual depiction means any visual depiction that, as a result of any type of digital, electronic, mechanical, or other modifications, alterations, or adaptation, depicts or a realistic version of an identifiable person. One, oh, excuse me, hold on, y'all. Oh, excuse me. All right. With the new body parts of another person as the new body parts of an identifiable person. With computer-generated new body parts as the new body parts of an identifiable person engaging in sexual conduct in which the identifiable person did not engage. An identifiable person means the person in the image is recognizable as a real individual, for instance, by their face, likeness, or other distinctive features such as a unique birthmark. Willfully means that Ms. Cooper acted knowingly, intentionally, and purposefully. Maliciously means Ms. Cooper acted with wrongful intent, for example, intentionally doing a harm act without any lawful justification, or excuse. To promote means to distribute and disseminate material, including issuing, selling, giving, lending, delivering, transmitting, publishing, posting, circulating, exhibiting, or sharing it, or agreeing to do so. To do any of these actions. Without consent means Ms. P did not agree to authorize an altered depiction being shared by any manner. The presence of a disclaimer within an altered sexual depiction, which notifies the viewer that the person or persons depicted did not consent to or participate in the creation or promotion of the material, or that the person or persons depicted did not actually perform the actions portrayed, is not a defense and not relieve a person of liability under the law. If you find that the above elements are proven by the preponderance of the evidence, then you should find for the plaintiff of this claim, on this claim, However, if the plaintiff fails to prove any one of these elements, you must return a verdict for the defendant on this claim. Okay, so we are on page 41. We got 5 pages left. All right. So instruction number 23, which is damages, defamation, and intentional infliction of emotional distress. If your verdict is for Ms. Cooper on defamation and intentional infliction of emotional distress, you will not consider the matter of damages. But if the preponderance of the evidence support either of Ms. Pete's claims for the defamation of intentional infliction of emotional distress, you should determine and write on the verdict form in dollars the total amount of loss, injury, or damage which the greater weight of the evidence shows will verily and adequately compensate Ms. Pete for her loss or damage, including any damages that she is reasonably certain to incur or experience in the future. You shall consider the following elements of damage. However, if clear and convincing evidence supports Ms. P defamation claim and or the preponderance of the evidence support Mrs. P claim for intentional infliction of emotional distress, you should determine and write on the verdict form in dollars the total amount of loss, injury, or damage which the corresponding burden of proof shows will fairly and inadequately compensate Ms. P for her loss and damage, including any damages that she is reasonably certain to incur or experience in the future. You shall consider the following elements of damage. A, special damages. If you find for Ms. Pete and against Ms. Cooper on Ms. Pete defamation claim, you may award special damages. Special damages are damages which are awarded because statements Ms. Cooper made arose to the level of defamation per se as I prescribed. B, nominal damages. If you find for Ms. Pete but find no damage has been proved for her intentional infliction of emotional distress claim, you may award nominal damages. Nominal damages are damages of an inconsensual amount which are awarded to vindicate a right where a wrong is established but no damage is proved. By nominal, I mean a dollar amount of damages such as a dollar that you, in your discretion, determine. See compensatory damages. If you find that Ms. Pete and against Ms. Cooper on the intentional infliction of emotional stress claim, you may award compensatory damages. Compensatory damages or damages amount awarded for one, medical expenses for Ms. Pete. These compensatory damages are for the reasonable value or expense of medical care and treatment necessarily or reasonably obtained by Ms. Pete in the past or to be so obtained in the future. Two, lost earnings, lost work time, lost earning capacity. These compensatory damages are for any earnings, working time lost in the past, and any loss of ability to earn money in the future. Any loss of ability to earn money sustained in the past, and any such loss in the future. Three, injury to reputation or health or shame, humiliation, mental anguish, hurt feelings. These compensatory damages are for any injury to reputation or health and any shame, humiliation, mental anguish, and hurt feelings experienced in the past or to be experienced in the future. There is no exact standard for fixing the compensation to be awarded on account of such elements of damage. Any award should be fair and just in the light of the evidence. D, punitive damages. There is an additional claim in this case that you must decide. If you find Ms. Pete in against Ms. Cooper on her claims for defamation or intentional infliction of emotional distress, you must decide whether, in addition to compensatory damages, punitive damages are awarded as punishment to Mrs. Cooper and as a deterrent to others. Ms. Pete claims that punitive damage should be awarded against Ms. Cooper for her conduct in coordinating with Mr. Daystar Peterson and his affiliates to distribute, promote, and disseminate false and disproved statements and theories about Mrs. Pete, and to intentionally or recklessly promote and distribute an altered sexual depiction of Ms. Pete. Punitive damages are warranted against Ms. Cooper if you find by clear and convincing evidence that Ms. Cooper was guilty of intentional conduct or gross negligence, which was a substantial cause of loss or damage to Ms. Pete. Under those circumstances, you may, in your discretion, award the punitive damages against Ms. Cooper. If clear and convincing evidence does not show such conduct by Ms. Cooper, punitive damages are not warranted against Ms. Cooper. Intentional conduct means that Ms. Cooper had an actual knowledge of the wrongfulness of the conduct, that there was a high probability that injury or damage to Mrs. Pete, and despite that knowledge, she intentionally pursued that course of conduct resulting in injury or damage. Gross negligence means that Ms. Cooper's conduct was so reckless or wanting in care that it constitute and conscious disregard or indifference to the life, safety, or rights of persons exposed to the conduct. Instruction number 24. Statutory damages, promotion of an altered sexual depiction. If your verdict is for Ms. Cooper on promotion of an altered sexual depiction, you will not consider the matter of damages. But if the preponderance of evidence support Mrs. Pete claim for promotion of an altered sexual depiction, then the law allows Ms. Pete to recover monetary damages in an amount of $10,000 or actual damages occurred, whichever is greater for each instance that occurred, in reasonable attorney fees and cost. This is instruction number 25, which is duty to deliberate when only the plaintiff claims damages. Of course, the fact that I have given you instructions concerning the issue of Miss Pete's damages as to any of her claims should not be interpreted in any way as an indication that I believe that Mrs. Pete should or should not prevail in this case. Your verdict must be unanimous. In other words, you must all agree. Your deliberations are secret, and you'll never have to explain your verdict to anyone. Each of you must decide the case for yourself, but only after fully considering the evidence with the other jurors. So you must discuss the case with one another and try to reach an agreement. While you're discussing the case, don't hesitate to re-examine your own opinion and change your mind if you become convinced that you were wrong. But don't give up on your honest beliefs just because others think differently or because you simply want to get the case over with. Remember that In a very real way, your judges of the facts. Your only interest is to seek the truth from the evidence in the case. And then we're on our last page, which is instruction number 26, election of foreperson, explanation of verdict form. When you get to the jury room, choose one of your members to act as a foreperson or act as foreperson. The foreperson will direct your deliberations and speak for you in court. A person, oh, y'all give me 1 second. Oh, had to clear my throat, y'all. The foreperson will direct your deliberations and speak for you in court. A verdict form has been prepared for your convenience. Explain verdict. Take the verdict form with you to the jury room. When you've all agreed on the verdict, your foreperson must fill in the form, sign it, and date it. Then you'll return to the courtroom. If you wish to communicate with me at any time, please write down your message or question and give it to the court security officer. The court security officer will bring it to me, and I'll respond as promptly as possible, either in writing or by talking to you in the courtroom. Please understand that I may have to talk to the lawyers and the parties before I respond to your question or message. So you should be patient as you await my response. But I caution you not to tell me how many jurors have voted one way or the other at the time. That type of information should remain in the jury room and not be shared with anyone, including me, in your note of question. And that is the end of this. Oh, I read this pretty fast, y'all. We finished this in 56 minutes. All right, so what do you guys think? What are your thoughts? Leave your questions in the description box below. I am shooting for 500 followers or subscribers, however you say it on YouTube. If you like what you see, hit the like button. It's free. Hit the share button. Share it. Hit the subscribe button. It's free. And until next time, and y'all know, as I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. And with that being said, I'll see y'all next time.